Real estate contracts. Real estate professionals who are not licensed attorneys may not practice law. Pre-printed contract forms may be prepared by a trade association, firm attorneys, or as mandated by state law. Written agreements used by real estate professionals. The written agreements most often used by real estate professionals are client representation agreements, sales contracts, option contracts, escrow agreements, property management agreements, leases, and owner financing agreements, such as land contracts or contracts for deed. Contracts in general contain promises. A contract defines each of the parties' legal obligations and rights. The essentials of a contract. A valid contract is one that complies with the provisions of contract law and contains 4 essential elements: contractual capacity, offer and acceptance, legality of the object, and consideration. There's 2 types of consideration. There's valuable, which is measured in money; good, which is measured in love and affection. So what is time is of the essence? What does that mean? It means that each of the elements of the contract must be performed within a specified time. If someone fails to perform an obligation under the contract within the time frame, they're liable for breach. An amendment is a change or modification to the existing content of a contract. It can also be a change to the existing words or provisions in a pre-printed contract form. It must be separately initialed by all parties prior to or at the time the contract is signed. Now, an addenda is any provision added to an existing contract that may change and be in addition to the content of the original. Amendments and addendums can be used to alter the terms of a pre-printed contract during the negotiation of a sale or to include additional terms after the contract has been signed by the parties. Option contracts is a unilateral contract. You have the optionor and the optionee. The optionor is the owner who has obligations. The optionee is the potential buyer who has the right to buy. The consideration, there's information that's required. You have to determine whether options are going to be assignable. And the requirements for a licensee is to make sure that they get valuable consideration. Void, voidable, and unenforceable. A void contract does not meet all the required elements of a valid contract and therefore has no legal effect. You might as well throw it in the trash. A voidable contract, on the other hand, is a contract which one party may cause the contract to be voided, but the other party is required to perform. Unenforceable is a contract with all the required elements but will not be enforced in a court because of one of 2 things. It either does not comply with the statute of frauds or exceeds the time in the statute of limitations. Notice, delivery, and acceptance of contracts. Once the last signature is complete and acceptance has been conveyed to the other side, the contract becomes binding. Purchase agreements, otherwise known as offers. We're going to talk about general requirements, binding the offer, contingency, and the fact that time is of the essence. Sell and purchase contract, you have a vendor and a vendee. You're going to need to know the difference in your E's and your O's. O's give, E's receive. So a vendor is the seller. A vendee is the buyer. It is a bilateral contract that's in writing and signed due to the statute of frauds. Some of the information that's contained is the names of the vendor and vendee, legal description, consideration, total purchase price, financing or cash terms, title evidence, type of deed, expenses and prorations, personal property to be included, the closing date, time and place, and the date of possession of the property. The contingencies included in a sales contract allow a buyer to have an attorney review the contract, secure financing, conduct necessary inspections, and perform other activities. Contingencies are conditions that must be satisfied before a sales contract is fully enforceable. Counteroffers. That's when a seller counters, makes a different suggestion of a sale after the buyer has presented an offer to them. And counteroffers can go back and forth several times before there's a meeting of the minds, or somebody just gets tired and they say, I'm done with it. Multiple offers happen when you have a hot property that everybody's wanting to get in on. And before an offer is accepted, you've got several offers coming through. Your broker will instruct you on how to handle that